We're going to get started. Are you all set? Okay, thank you. Thank you. Good morning, everyone. I'm going to call the committee into order, and if we could start with introductions. Representative McIntyre.
Thank you, Madam Chair. Good morning, Matthew McIntyre, representative for House District 18.
I'm Senator Scott Searway, and I represent District 16, which covers Waterville, Winslow, Oakland, Fairfield, and Albion.
Good morning. I'm Representative Bob Nutting. I represent the towns of Oakland, Smithfield, Mercer, Starks, and a portion of Sydney.
Representative Tavis Rock Hassenfuss, Reedfield and Winthrop, House District 57.
Representative Bunker.
Representative Steve Bunker, District 75, Farmington and Chesterfield.
Good morning, Representative Michael Joy. I represent District 96, which is part of Lewiston.
Good morning, everyone. Nina Milliken, House District 16, the Blue Hill Peninsula and the town of Trenton.
And I'm Senator Penny Beebe Center, and I represent all of Knox County except for Idaho and the town of Washington. We're going to start with LD 1962, a bill to establish the corrections ombudsman. Will, would you like to introduce yourself?
Yes, my name is Will Tu, and I'm the legislative analyst for the Criminal Justice and Public Safety Committee. We do have LD 1962 first today on our schedule. Before we get into it, I just want to give a little bit of an overview of where we're at in terms of the committee's work. As you'll recall, the first day we met on January 6th, the presiding officers requested, per their guidance, for all carryovers to be voted by January 30th. That's this Friday. We had 12 carryovers, not including placeholder bills, which aren't subject to that same January 30th deadline. Of those 12, we voted 3, and we have 9 remaining, with 5 today up for work sessions. Those 4 obviously on Monday were canceled due to the snowstorm. Those will likely be rescheduled the following week. So I think we've got a little bit of an exception there. We are allowed to submit extension requests to the presiding officers about the bills, the carryovers that we haven't voted for January 30th. Hopefully, I'm not submitting a memo requesting 9 carryovers. Hopefully we can deal with some bills today because I think it is subject potentially to presiding officers may have alternatives if we're not able to vote all of those carryovers. So to the extent possible, hopefully we're able to vote what we can today. But that's where we're at in terms of the carryovers. And then once we've addressed those, we can move on to our new bills, which, as I mentioned before, isn't a huge load. I think the session's a bit more front loaded with the amount of carryovers we had. So hopefully smooth sailing ahead. But do not quote me on that.
Okay.
Okay, so back to LD 1962. This was an act to establish the corrections ombudsman. If you'll recall from the work session, I believe it was last week, number of issues, and there was we tabled it and requested to work on it a bit further. I do have an amendment from Rep. Milliken here that I provided to you on your desks. So this would strike the entire bill, change the title, and it accomplishes 2 things. First, part of the conversations we've had is the Board of Visitors exist in statute as part of an oversight mechanic. That allows individual citizens to come to the correctional facilities, observe what's happening at the facilities, talk with residents, figure out what the problems they're facing, and they report on those issues. But there are some boards that are partially filled. There are one that is completely vacant. So to address that, this is something that gets at that issue. Currently, the governor has the sole power to appoint the Board of Visitors members. So this would be a new section, section 1 here, that states if a vacancy is created within Board of Visitors, the commissioner provides a notice to the governor, the president of the Senate, and the Speaker of the House within 5 days of the vacancy. The vacancy on a Board of Visitors under this section, it's got to be filled by the governor within 90 days of the notice of vacancy. And then once that 90-day lapses and the governor has not appointed a member within those 90 days, Then it would transfer over to the President of the Senate and the Speaker of the House of Representatives, which would allow them to jointly appoint a member to fill the vacancy pursuant to the regular subsection. So still the same membership requirements would apply that we discussed previously. I can stop there. Rep. Milliken, I don't, if you have any additional clarification, that's totally fine, or I will continue going with section 2. I think it's fairly straightforward, but okay.
If, I know you get to leave in a few minutes, if you could.
I would just point out, I guess, and I think you just said it very well. Thank you, Will, that we have had vacancies at the Maine State Prison Board of Visitors for coming up on 2 years. The executive has failed to appoint people to those boards despite the recommendations of the Department of Corrections of people to fill those vacancies with. And it seems to me that we as the Legislative Oversight Committee should have some recourse here in the absence of an appointment by the chief executive. So I would provide that.
Yes, Representative McIntyre.
Thank you, Madam Chair. Just a point of clarification for me as a hypothetical. Should this situation play out where the chief executive fails to fill those vacancies on the Board of Visitors and a legislator from this committee is appointed to fill that, is it a temporary fill?
No legislator can fill that seat. Legislators cannot, the legislature would make the appointment, but we couldn't appoint a legislator
Okay.
to the Board of Visitors. There's prohibition already in the Board of Visitors statute.
So thank you for that clarification.
Yes.
I appreciate that. That clears it up for
Is
me.
that good?
Thank you.
Okay, excellent.
Yeah, sorry, it's a little confusing without the full statute because the final sentence pursuant to the subsection that houses all the exceptions of like, who needs to be on the board, who can't be on the board. But yes, Representative Milliken's right. It explicitly does not allow legislators to be on those boards. So moving on to section 2 then, legislator access to correctional facilities. So this somewhat mirrors, 2 parts. If you recall from the Correction Ombudsman bill, there was a portion that allowed the Correction Ombudsman to have access to correctional facilities and detention facilities, even in instances of emergency situations. So this is a modified version of that, plus how the Board of Visitors currently operate. So essentially, each legislator assigned to the Joint Standing Committee of the legislator having jurisdiction over correction matters. So us, or perhaps a future committee in the future that is not CJPS, but has similar charges or jurisdiction, would allow legislators full access to the correctional facility and detention facility, which is Long Creek, including access to area housing clients. So again, this is similar. Board of Visitors have this similar power right now. A legislator must be provided the opportunity to speak with clients and facility staff. A legislator shall adhere to all federal and state law regarding confidentiality. The chief administrative officer of a facility may only prohibit a legislator's access to a facility if an emergency situation is certified pursuant to section 3005. So again, that section is more, I think, along the lines of the Ombudsman bill when it was considering hostage situations, riots. So that's going to be a carve out that they still have the ability to exclude legislators when those emergencies are declared. But in all other situations that legislators of this committee would have full access to the correctional facility and Long Creek.
Any questions, Senator Sirway?
Thank you, Madam Chair. So with this, from my understanding is, like LD 1971 puts a communications problem with our police and federal. So the ombudsman's going to have more authority of information than the law enforcement, correct?
Yes, so you might have come in late on this. This amendment that's in front of the committee is striking the entire bill. So an ombudsman position is no longer being established under this amendment.
Okay, and
So there's just 2 parts of it of allowing the presiding officers to appoint vacancies on Board of Visitors for correctional facilities. And then the second part is just allowing legislators of this committee access to correctional and detention facilities so they can observe issues with the facilities, problems that residents are having, issues with the facility, et cetera.
so is that allowing us to have more authority than the law enforcement as far as knowledge?
I don't know in
I'm
terms
just
of,
asking the question.
the Department of Corrections can speak to that if they want. I don't know what their current rules are in terms of I imagine members of the public, there's certain rules, but if a law enforcement officer, I think it depends on what purpose they're there for as well. I imagine if they're there on law enforcement business, then I imagine that they would probably be allowed the similar access, but instead of speculating,
Will, can we
You can ask
ask
the
someone
Department
to
of
come up and
Corrections.
maybe
Yeah.
ask them?
Yeah.
Could someone from DOC come up? Thank you.
Morning.
If you could introduce yourself.
Morning, Senator Beebe Center, Representative Hassenfuss, and distinguished members of the committee. My name is Jill O'Brien. I'm the Director of Government Affairs for the Department of Corrections.
Thank you.
So I think Senator Sierrawaite's question was, I guess, under this amendment of allowing legislators to have access to facilities, and I think it might help too of what they would currently be allowed to do and what they're currently not allowed to do, and how that would compare. I guess your question is just law enforcement officers.
Yeah, we'll just say if we needed to know information about federal information or whatever. Right now, as it stands, we can't, as law enforcement officers in this state, look into any federal information where we're supposed to be not communicating at all. So how does that work when it comes to legislators? It sounds like legislators are going to be able to, but law enforcement can't. So how does that work?
I think law enforcement is still privy to information about individuals in the Department of Corrections custody. And 1917 or 71, excuse my, I don't remember the number, has a lot of intricate exceptions. For example, if it's a very serious crime, if someone's been convicted of a Class A, some of it doesn't apply. So I think it's a little bit more nuanced about when law enforcement can and can't cooperate in the state of Maine. With respect to, I think law enforcement and DOC in the state of Maine regularly share information about probationers, about people in the community that they're investigating. So that won't change. Legislators who come in are even now, legislators frequently do come into our facilities, and their residents can share what information they volunteer with those legislators. We don't give out information to legislators. It's only what they would observe or what a resident would choose to share with them. Does that answer your question, Senator?
Well, not quite. I'm looking at this and it looks like we're allowing them to go in and get the information. I feel that 1971 is kind of like taking the computer out of a car and it can't communicate to all the parts. And we're in a situation here where this is allowing that communication from legislators, but not the law enforcement to take care of what we need to take care of. So I'm concerned where we're putting this in, having people that don't understand law enforcement, some of them, and then others, then we're taking the other piece out. So I don't see how this is going to work.
And we would object to if the legislators were thinking under this amendment that they would have full access to the DOC's computer system or something. That's not what I think is being envisioned. I think it's the types of visits the legislature is currently doing. The department still objects to the amendment. It's not just emergencies that dictate when it's safe for a legislator to come in. If staffing is so low that we can't protect residents and the legislators from disturbances or incidents, the wardens need the authority to be able to say, not today, come back tomorrow. So the department still objects to this amendment in that realm. And on the Board of Visitors piece, I think the committee should hear from some of the existing Board of Visitors members before making wholesale changes to those boards.
Thank you.
Representative Ardell.
Thank you, Madam Chair. My name is Donnie Ardell. I represent House District 6. And thank you for coming today. Looking at Section 2 of the amendment, I was by no means a supporter of the original bill. However, I'm kind of looking at this section, and I'd like your opinion on whether it is appropriate for individual Maine legislators to be conducting their own sort of investigations on their own. It seems to me that the appropriate mechanism between the legislative and the executive branch in this case, Department of Corrections, would be to request information from the department formally. It seems to me there's been open channels of communication for that. It just seems inappropriate for me for individual legislators to be sort of willy-nilly, like wandering about our correctional facilities, conducting their own independent investigations. And I'd like your opinion on that sort of perspective of the second half of this bill.
Thank you, Representative. We would agree with that. There are certainly agencies of the legislature that can conduct investigations if the committee so chooses. Information requests, we are very forthcoming with information requests with this committee. I think legislators should have access just like members of the public. Prisons often do tours. We should all be aware of what is going on inside our facilities because it's under our laws and it's our tax money that is running these institutions. So everyone should have a level of awareness of what is happening, and we support that, but we 100% agree that there shouldn't be individual investigations going on.
Thank you. I appreciate that forthcoming response. As a result, Madam Chair, I would like to make a motion of ought to pass, but to amend the bill to completely strike section 2 and to include section 1.
Second the motion. Any further discussion? Representative Milliken?
Yeah, thank you, Madam Chair. I just wanted to respond, I guess, to Representative Ardell. Part of the purpose of the legislature is to act as a check on the executive branch. And I understand that legislative bodies seem to be forgetting that important role of the legislature in recent months. It seems to me like this would provide us a more robust ability to be an oversight mechanism and what is currently the only oversight mechanism of the Department of Corrections. And while I appreciate that the Department of Corrections has been very forthcoming with information, sometimes in my experience, the information that I get from residents is different than the information I get from the department. And often I've had the ability to reconcile that in communication with the department, but it seems that it would be helpful to get more robust picture of the situation if we were allowed access to the Department of Corrections. And I understand the safety concerns, which is why I asked that we include the prohibition on certain situations. It just seems, I guess, not sensical to me that a Republican member of the legislature would abdicate their duty to be an oversight mechanism and hand it over to a Democrat-dominated department executive and just forego the responsibility, shirk that responsibility of our role here in the legislature. I obviously won't be supporting your motion, and I encourage my colleagues to consider passing this amendment for the purpose of fulfilling our obligations as elected officials and a check on the executive branch. Yeah.
Any further discussion about, yes. Representative Nutting.
Thank you, Madam Chair. I don't think I like the bill, even part 1. I certainly don't like part 2, and I can't think of another agency where I've served on probably 6 different committees. I would never felt that I should be allowed to wander around in the DHS building or the transportation garage or anywhere else. If we have a problem with a department, we have the ability, or the chairs certainly have the ability, to drag them in here and sit them in that seat and read them the Riot Act. That's the way the legislature deals with agencies that are under the control of the governor. The reason I don't like the bill at all is if we had a governor who did their job on the part 1, we wouldn't need the Senate president and the Senate, and the Speaker of the House to do their work. So I don't like the whole bill. I'm not going to support Representative Ardell's bill motion either. Thank you.
Representative Hassenfuss.
Just procedurally, well, was there already an ought not to pass motion on the table from motion that was made when we previously tabled this? And I believe if there was.
Bernice, do you have one? I mean, I can go back to my.
And I believe if there was, whoever made that motion would need to rescind that and then.
Welcome.
Yeah.
Can we find out if in fact that was the motion, who made it, and who seconded it?
Representative Ardell?
Thank you, Madam Chair. I think it extremely likely that motion was made by me.
And so are you withdrawing your motion to
And
then make
so
your?
in the event, in the extremely likely event that it was, I would like to withdraw the former motion of ought not to pass because this is a completely different bill. And I'd like to then make a motion of ought not to pass on the amendment because in sort of review of it, I agree with the representative from Sydney. I think really the governor has a responsibility in existing law to appoint members of the Board of Visitors. That is the Board of Visitors job. That is the reason we have a Board of Visitors. So the second half of this amended legislation, Section 2, is completely unnecessary if the Board of Visitors is actually functioning as intended and staffed as intended. And really or staffed as intended by the governor, who apparently has no interest in filling the open positions on the Board of Visitors. So to sort of wrap this up, I'd like to make a motion of ought not to pass on the amendment. Thank you.
Will, did you want to say something?
No,
Okay.
I thought I found it in my notes, but that was something else. No.
Representative Milligan?
Thank you, Madam Chair. Again, just want to respond. You have the ability to go to the Department of Health and Human Services and walk around their buildings and go to parking garages. And I think that's the key difference here. And to respond again I agree with you, Representative Nutting, that the governor is not doing her job in this instance. And because we are supposed to be a check on the executive branch, I would like to take that responsibility from her if she is not willing to do her job. And I say that as a Democratic lawmaker with a Democratic governor in office. If she's not willing to do her job, this is me taking my opportunity to act as a check on the executive branch, despite the fact that we're from the same party. And I find it odd that neither of you would like to do the same.
Yes. Representative McIntyre.
Thank you, Madam Chair. Clarifying question, hypothetical again. Listening to the conversation. During the initial discussion on this, I stated on the record, I believe in government oversight. I do. And I still do. My question is, do we or do we not have a government oversight joint standing committee? And the hypothetical is that if we have the access to these facilities that has been described, and we were to see something that troubled us or led us to want further investigation, couldn't the chairs of this committee send a letter to the already established government oversight committee to follow up on that? That's a hypothetical that I toss out, and please pick it apart.
I believe that's possible. I will.
Yeah. I wish we had our GOC member here, but I mean, yes, of course, anything that we subject to government quasi-independent could be submitted to GOC.
Okay. Yes, Representative McIntyre.
Turn the mic on.
I second the ought not to pass.
Is there any further discussion on the proposal? Yes. Representative Bunker.
Thank you, Madam Chair. Just thinking back over the years, and I either am on or have been on a number of boards and commissions. And the delays in making appointments or reappointments transcends multiple jurisdictions, governors, oversights, I'm afraid to say. And I've been a party to that and have been in acting capacity waiting for reappointment for more than a year on many of those issues. So it's not unique just to this one. But my question is back to Department of Corrections, if you will. As a legislator, then, given the current guidelines, and I made an inquiry to visit a correctional facility, would I be given any more, less, or the same as a citizen who would like a tour?
So you would have, I think the answer is the same. We certainly have legislative tours. I've been on 4 in my short time with the department. And the public's access is a bit more prescribed in the sense that there is a background check that is foregone for legislators. There's some mechanics there that are different for the legislators, but in general, with the wardens, the chief administrative officers of the facilities certainly would have the authority to let people in and to have them leave if things become escalated or they need to. And I say that because on a given day, if staffing is very low, it wouldn't be a good time for anyone to tour. Or on a day where there was an outbreak of the flu, for example, there's powers given to the wardens to say when tours are good, but in general, access when it's safe and appropriate is the same for the public and the legislature.
Follow up?
Last follow-up, I promise. I respect Representative Ardell's concerns about individual legislators going off on their own on some investigation, if you will. That there should be a need for proper communications as to the nature of why I would like to be in a facility. But if that was the case, I would have assumed that I would have been granted greater access to the facility beyond a tour if I wanted to talk to inmates or staff. It's part of my role here. So it's a bit more limiting than what I anticipated. And that's why I was intrigued by section 2 on here that would give me that type of resolve.
Representative, I may have misled you. May I respond?
Please.
Certainly legislators are allowed to talk to prison residents, and members of the public aren't prohibited from talking to prison residents either. It's entirely up to the resident if they want to interact with someone who's in the prison.
Representative Hasselfist.
Thank you. And Ms. O'Brien, is there
Mike.
is there a specific policy that the DOC has related to legislators or members of this committee visiting the correctional facilities?
There's a general visitation policy that applies to everyone. It's on the website.
But there's no specific policy regarding legislators?
No.
Representative Milligan.
Thank you, Madam Chair. I just want to let the committee know I've done the tour at Main State Prison a couple of times. I've done one with you, Mr. O'Brien. And the prison looks very different when you go in for a tour versus when you go in just for a random day. And that's not to say that I just think you get a very different picture when you are on a tour and you're given an opportunity to have it scheduled and see the prison at perhaps an opportune moment than when you just go in randomly.
Is there any further discussion? Yes, Representative Ardell.
Thank you, Madam Chair. Just to sort of clarify, have any requests for tours or access to DOC's facilities been denied by DOC in the recent past? My understanding is that there have been legislators traipsing around the facilities, acting as sort of de facto ombudsman recently. And has there been any denial of that?
So legislators regularly walk around facilities. Representative Milliken goes often, and I would disagree with the characterization that tours are different than off days, but we certainly welcome members of this committee on off days. We are trying to be transparent about what is going on inside the facilities. I believe Representative Milliken tried to visit within the last 2 weeks and was unable to, and I believe staffing was the concern that day. I don't have the specifics on that, but to answer your question, I know of one time a legislator was unable to visit when she wished.
And the reason for that was staffing was reduced and for probably safety reasons, it was inappropriate at that time.
Well, even as a practical matter, a legislator can't swipe themselves into different parts of the prison, so they need to be escorted.
Well, it is a prison. Thank you.
Representative Milligan.
Thank you, Madam Chair. I'd like to clarify that 3 of the last 4 times that I asked to go to the prison and had permission to come down and be there, I was denied access.
Is there any further discussion on the proposal? Is the committee ready to vote? Oh, it's okay.
The motion on the table is sought not to pass by Representative Ardell, seconded by Representative.
Sorry.
Okay,
Would it be okay if we caucus for 5 minutes, just 2 minutes long? May I keep it?
Yes, yes.
Yes.
Getting better every day.
oh, yeah, the Titanic.
Thank you very much, Mr. Chair. I think we have to remember, which is with, it's pretty clear. Most of us just speak of juveniles.
I do.
POC can dispose of description, local graph, new name, location, like location. Notice do not approach the juvenile plus to contact the law enforcement if they believe they're just getting without juveniles. Very limited, limited to. Well, pictures. The motion on the floor for LD 1962 is ought not to pass by Representative Ardell and seconded by Representative McIntyre. Representative Hassenfuss,
No, voting against the ought not to pass.
Representative Nutting,
Yes.
Senator Searway,
Yes.
Representative Abdi,
No.
Representative McIntyre,
Yes.
Representative Ardell,
Yes.
Representative Bunker,
No.
Representative LaJoy,
No.
Representative Milliken,
No.
and Senator BB Center.
No.
Okay, and the alternate, the opposing motion is,
Ought to pass as amended using the Milliken amendment.
okay, thank you. So we have 4 for the motion of ought not to pass, 6 for the motion ought to pass as amended by Representative Milliken, and 3 absent.
Well, I'm gonna,
Excuse me?
You have a separate motion?
yeah, it's gonna be section H is gonna be the same. Section 2 is going to direct the department to make major substantive rules regarding policy for visiting legislators.
Okay.
Is anyone on Representative Hassenfuss's motion?
I think that's just mine by myself.
Okay. All right. Thank you.
You have to go.
Oh, I'm gonna. Yeah, sorry.
So do we want to,
Let's take a brief break, come back.
for what?
We need to take a break.
For what?
So I can talk to the other stakeholders and figure out what amendment, see if we can agreement on it. So let's take a break
For this amendment and for this bill?
before we take up 1 up 2. Let's take a 10-minute break
To do what?
to discuss it with the department and with all of the stakeholders to see if they came up with something. I think I just need a little bit of time to go over some of the documents, figure out what we're doing.
Yep.
Take 10 minutes.
Remind you that there are checks to sign in the back.
That there are what?
3 checks.
Jackets. Okay. Yep. So I don't.
Senator.
Thank you.
So she had one that you came in the email, right? And now she's got it.
Yeah, and this is kind of like taking everything.
This your bill?
So this is like. Everybody's.
Yes. Yeah. Good bill.
No.
I think it's. Reason being, neither department likes this. It's the amendment. They can live with the amendment and they can get the proper information out to get the individuals.
And safely,
Lifestyle.
and safely.
Well, I think sounds good. I mean, I like the intent is good.
Well, then the wording is good. So, okay, are we ready to? Will, are we ready to go?
Yes.
Would you stay?
I think you have to say. So we have LD 102. I don't know if we've opened the work session on this yet, but I guess this acts as it. This is an act to notify the public of juveniles who are wanted persons. This is our fifth work session on this bill, and as they say, the fifth time's a charm. So hopefully we're at that point. There's been a number of amendments that have been provided to the committee. Constantly trying to find this balance of what's the appropriate amount of information to release to the public? What kind of process does that need to go through? Is a judicial officer required in this situation? So as my discussion 30 seconds ago with the Associate Commissioner, there is another amendment that the DOC also worked with Tanya Pearson from Maine Prosecutors Association. It sounds like there is some consensus on this amendment. So I guess I would defer to the Associate Commissioner to detail the amendment to you. I don't think we have written copies available today, right?
Right.
But if you guys agree in substance on the topic, then it's something that we could review, or we will review at language review.
Okay. Please.
Good morning,
If you could-
Senator Beebe Center, Representative Hassenfuss, members of the Criminal Justice and Public Safety Committee. My name is Christine Tebow, Associate Commissioner for the Department of Corrections, Division of Juvenile Services. So the proposal that we're making this morning would be captioned escaped juveniles, and it would be located in Title 15 MRSA Section 3308A, subsection 4-C. And the bill would read that the Maine Department of Corrections may publicly disclose for purposes of identifying and apprehending a juvenile who escaped from a Maine Department of Corrections facility and for whom there is probable cause to believe that the juvenile presents a serious risk to their own or public safety. The following information: a physical description of the juvenile's recent location, likely locations of the juvenile, the fact that the Department of Corrections is searching for the juvenile, and instructions not to approach the juvenile, but to report any sightings of the juvenile or relevant information to any law enforcement agency. So it does not allow MDOC to publicly disclose the name or the photograph of the juvenile. Of course, law enforcement agencies are permitted to have that under existing law. So this bill really limits the amount of information that can go out only when a juvenile has escaped and there's reason or probable cause to believe that they present a serious risk to themselves or others.
Yes, Representative Cutting.
Thank you, Madam Chair. Does this relate only to state facilities?
Well, right now, there's only one juvenile facility in the state, and that's run by the Department of Corrections, and
Are
that
there
is Long Creek.
I'm sorry. Are there juveniles in any jails, or
No.
are they immediately moved to Long Creek?
They're not allowed to be held in jail. Well, they're very narrow exceptions temporarily for a limited period of time.
So this
but
specifically deals with Long Creek.
yes.
Okay, thank you.
Representative Ardell.
Thank you, Madam Chair. Hello, Ms. Tebow. The, that so escapes, and I don't recall the detail in Maine law. Isn't it true, though, that an escape, there has to be a certain status of the subject for it to be considered an escape? Could someone who was arrested and then attempted to, escape, really, for lack of a better word, would they, in the proposed legislation, would they have to actually be an inmate or resident of the facility, or would a mere arrest sort of, and I say mere arrest, but would an arrest trigger that status where the escape law would come into play? If that makes sense.
It does. This proposal only applies to youth who are in a DOC facility. You are correct that juveniles are sometimes arrested by law enforcement and sometimes leave custody of said law enforcement, and that it does constitute an escape. But this bill for today only applies to juveniles who are in a correctional facility.
As part of your negotiations, sort of, and thoughts on the bill and on the amendment, do you think it would be sort of, I don't know, simpler maybe, or wiser to be able to just sort of, because I do like the language. I do like the application of probable cause. I think that makes sense. That's a breakover point that people in the industry are under, readily understand and readily use. I think the photo might be a little questionable, but I would think I like the description, location, search ongoing, directions not to approach. I think that's fair and addresses public safety pretty reasonably. But do you think restricting this to merely escapes from DOC custody is wise? I mean, this seems like a policy that could be applied to any juvenile who could be considered a risk to themselves or the public, regardless of their arrest status, regardless of their DOC residency, if you will.
Mhm.
What are your thoughts on that?
Well, I agree with you that there are other situations aside from being in custody that would make sense. However, I am here this morning as a representative of DOC, not the Department of Public Safety. So I would leave that discussion to include law enforcement officers in general.
And it would probably be a different bill.
It might, but I think there might be room for an amendment. Do we have someone in the gallery who could maybe provide a perspective of law enforcement more generally?
Representative Perkins?
Thank you, Madam Chair. By way of introduction, I'm Representative Chad Perkins, District 31. My understanding is we don't have a written copy of this.
No.
So, and I apologize for my tardiness. I was delayed, but would it be possible to have the Associate Commissioner, for my benefit, since I wasn't here and we don't have a printed copy, could she reread the proposed amendment for me? And I do apologize for
Certainly.
the time delay on that.
If you would do that, please.
Will. Yes, so this would be a statute captioned escaped juveniles. And it would allow Maine Department of Corrections to publicly disclose for purposes of identifying or apprehending a juvenile who has escaped from a DOC facility and for whom there is probable cause to believe the juvenile presents a serious risk to themselves or others, the following information: the physical description of the juvenile, juvenile's recent locations, likely locations of the juvenile, the fact that DOC is searching for the juvenile, and instructions not to approach the juvenile, but to report any sightings of the juvenile or other relevant information to local law enforcement.
Senator Sealy?
Thank you, Madam Chair. I just wanted to clarify that if the person is taken into custody, we generally have probation on juveniles included, so that's DOC. So why is that not in here? I mean, because that is an escape outside of the facility. So it should be under probation. So it's,
Well, I'm not sure I understand the question.
Okay, so we have a person in custody that's a juvenile
Mhm.
and the person escaped, but we know what crime he committed, whatever. We still have to call the juvenile officer,
Correct.
and that becomes under DOC. So, and if we want to give out that information, we still have to go through DOC to get that release so that we can give that information out. So it would still be under the umbrella of being under corrections. So that's what I'm saying.
Well, I believe that there's a distinction between a youth being in custody of law enforcement and DOC having instructed law enforcement either conditionally release that youth or take them to Long Creek. That's the purpose of the call to the DOC, is to make a decision. But at that point, that youth is not under the supervision of DOC. They're still in the custody of the arresting agency. And this bill only applies to situations where the youth is physically in the custody of DOC.
Well, this is my understanding that anything to do with juveniles, we have to go through DOC.
That is not exactly true. If you want to have conditions of release or detention, you have to go through DOC. But law enforcement has this broad discretion in dealing with juveniles. If a 5-year-old throws a rock through a neighbor's window, you do not have to involve DOC. That's something law enforcement can deal with without DOC. So it's only when the officer decides they want conditions of release or detention of the juvenile is DOC contacted at the point of arrest.
I guess we got to get clarity from the courts.
Okay, Representative McIntyre?
Thank you, Madam Chair. I believe I understand some of the rationale and the trepidation behind the use of photographs, although I don't completely agree with it. I understand where it's coming from. I guess my question would be, in the interest of trying to locate an individual that has by title escaped and is either a danger to themselves or others, I would think we would want all available tools to execute that quickly. So would there be any openness to a police sketch artist rendering?
Well, I think, keep in mind that local law enforcement gets everything. So a juvenile escapes from Long Creek, we give the name and the photograph to law enforcement. So they have the photograph and the name of the juvenile. What we are talking about in this bill is what does the public get? So we do a press release and we say,
Physical descriptors,
Yeah.
last known. Okay,
Okay,
thank you.
are you good? Okay. Are there any other questions? Representative Hassenfuss, do you have a question?
Yes, and then I'd like to bring up the ADA piece of the. Yes, thank you.
Okay.
Thank you, Deputy Commissioner. I know that, there's been a lot of work on this. Would it make sense to, I appreciate this amendment. I like this amendment. I think it kind of strikes that the balance that everybody has kind of been trying to look for this whole time. That being said, I think there could be more thought put into it. I'm just thinking perhaps, we put the statute in place and then maybe unallocated language that says, can we all think about this more and bring back any recommendations on how this maybe should be amended or changed to make sure that it's consistent with the changes we did in 2020 and is working well. So would you be open to sort of being the state agency that could facilitate that process with all of the stakeholders to see if there's something more or less that we should be adding to this?
yes, Representative Hassenfuss, and I think going forward, if there is any discussion about judicial oversight, we should be including members of the judicial branch. And if there's any discussion about law enforcement agencies and what they are able to disclose, we should be including members from that field as well. So, yes.
Yeah, well, thank you for that. And ADA Pearson, could you come up for just a minute? First, thank you for all of the work that you've done on this, over the last year. I'm pleased to see that we've finally come to something. Could you sort of answer the questions that we had previously about the process, but also explain, the focus on escapes and trying to keep consistent with all the work that was done a few years ago, to address the juvenile code and why everybody felt that this was the appropriate starting place.
Thank you.
If I
Yeah.
could ask you to do it as quickly as possible, we're going to lose half the committee at noon.
Okay.
Thank you very much.
Good morning. My name is Tanya Pearson. I'm an assistant district attorney for York County. In answer to Senator Searway's question about escape, and also the Department of Corrections involvement, escape from a law enforcement officer is a Class D offense. Escape from a facility is a Class C offense. It's a different classification of offense. The original bill did, as proposed by DOC, did talk about other offenses. It was broader than just escapes from Long Creek. In discussing the bill over the past year and a half, there is general agreement with the escape provision. I think it's extremely important to enact at least that section. I agree, and it is the MPA's position that it should potentially be broader, but as Associate Commissioner Thibault indicated, that would need to pull in judiciary because we would create a judicial process potentially, which could address the release of the photograph or the name. And we would also need to include law enforcement. So there are a lot of parties that aren't at the table currently for this. Does that answer your question?
Senator Searway?
Yes. It does some. I'm just thinking back, we had Escape from the Youth Center and we caught him. An officer allowed him to change, and when he did, he went out the bathroom window and escaped again. So now if you have, is that a Class D or is that
It's
another
still a-
C?
It's a Class D offense. The only time that it's a Class C offense is when someone is in a facility or they've escaped from a designated place, for example, by a facility, potentially.
Okay.
It's almost always a Class D offense that you're describing.
Representative Ardell?
Thank you, Madam Chair. Looking back at our analyst's assessment with the escape from arrest and escape during transport being a Class D, and with the language of the amendment that's been suggested to us, I think this is an important issue. I think there are times, restricting public access to a photograph is important to control, but it also can be a very, very important tool in identifying someone. So for example, if there's a 4'6" red-haired boy, approximately 10 years old, who's of immediate and serious danger to the public or himself, I would hate to have a situation where 4'6" red-haired boys would be being shunned in public, because of this announcement, where a photograph might be able to specify which 4'6" red-haired boy we're actually looking for. I think this has without providing the controlled ability to provide a photograph, I think the language of this amendment, the proposed amendment, maybe could cause a little more trouble or could be problematic and cause unintended consequences. I would also really like to see not just escapes from DOC custody, but escapes generally. Because I think I think the parameters of it, having probable cause that a juvenile is an immediate danger to themselves or the public, I don't think it really matters if they were coming out of DOC custody or if they were escaped from an immediate arrest or escaped from a transport. I think it would be a lot smarter for this committee to address this issue more generally, and instead of sort of hyper focusing on DOC specifically. And it sounds like with a time restriction today, this seems very rushed to me. I think the committee could do a much, much better job with maybe a little bit more time. And as a result, I'd like to make a motion to table this for specifically a written copy of the amendment, but also maybe some more thought about applying it generally. I think this committee could do very, very good work with more consideration and providing a more general guidance to the state of Maine as to, with these key elements: juvenile, probable cause, immediate danger to themselves or others. I think applying that generally would be a lot smarter than just DOC. And so I'd like to make a motion to table this. For now.
Representative Perkins?
Thank you, Madam Chair. Representative Ardell said many of the things I was going to say, but I wanted to add, and just a general comment, it's not a question but I sit on another committee where in that committee, it seems like every other committee meeting, we're talking about dead kids. And that is a travesty whenever we deal with dead kids in the state of Maine. And the issue that we deal with at this other committee is because there's always some process or some procedure or some failing on the part of the state government that leads to, in some part, us ending up with dead kids. And we hear radio ads about it. We have media coverage of it. People get outraged, and rightfully so, because there's no need, in my opinion, for there to be dead children in Maine because the government, whether it's as legislators or the bureaucracy that we create, fails kids. And while I completely understand the need for privacy, and what we're talking about here is we're talking about kids who have posed either a threat to themselves or to others. So if it were my kid, and I might be a little bit upset after that, yeah, my kid, his face was out there in the paper or on social media or whatever. My kid's alive. We put out all the information we needed so that we could find that kid and make sure that my kid was alive. And yeah, I might be a little ticked off later, I wouldn't be, but maybe someone would be that, yeah, okay, my kid's picture was out there, but that kid is alive. It's not another dead kid that we're talking about in Maine. And then this other committee that I sit on, we talk about it constantly.
Yeah.
And for me, I'm going to tell the committee now, this would be a deal breaker for me to not be able to release the information as needed to quickly and safely and expeditiously return kids to custody, because the parameters there, they are a threat to themselves or others. We can't have somebody dead because someone was worried about how embarrassed someone else is going to be down the road. We're talking about a real life safety issue here. I mean, it could be a dead kid, another dead kid. And then what do we have? They're not statistics.
Okay.
These are dead children. And I can't stand for that. So while I very much appreciate what the Associate Commissioner brought forward and then I support, I would definitely require that if the department required that photo to make sure that child, it's a child, it's a kid, was brought in safely. And so we don't end up with another dead kid, I would insist that the availability and to release a photograph be included in that. And, I like if I understood, and again, we don't have a written, my understanding is that the information, that the minimum amount of information required would be released. So that doesn't mean that the photo is going to get released on every kid. But if they need to do it, I don't think we should tie their hands, because I don't think Maine can stand another dead kid. And because of that, I think that I'm going to support and second Representative Ardell's motion to table.
Okay. Any further discussion on the table amendment?
Can't. No discussion on table motion.
Oh,
We have to just
okay.
vote the table motion.
All,
I just have a question on policy though.
Can't.
It's not about.
Yeah, but a tabling motion ends discussion. So there's no more discussion on this bill.
I thought he said that we couldn't table it anymore, but that's this day.
No,
We can
no,
request an extension.
Yep, we will.
the,
So we need to take a vote. All those in favor of tabling this?
I guess.
All those, that's everybody. All right. It's tabled. Thank you. You're welcome. So how many people are leaving at noon? One.
Well.
How many, who
No,
else?
no, just to clarify what I said that we've got, I think, 3 more bills.
We do.
I'm happy to stay past noon,
Oh,
but I'm not happy to take a lunch break and then come back and finish
okay,
after dark. So
okay,
1 o'clock, is my time to be gone.
okay. We can do that. Will, do we have the people we need for 1671?
There are some folks who I think plan to be here. I think Paul Gaspar, I don't know if the director of the Maine Criminal Justice Academy is supposed to be here, but it was technically scheduled. 9:30 was our juvenile bills and 11 a.m. was our law enforcement bills. So
Okay.
either we can continue with those bills right now and discuss, and if members want to table it, we could, and then wait till 11 o'clock, or we could take a 15-minute break, see who is here by 11 and whatever the committee prefers.
What would the committee like? Want to take a 13-minute break?
Come back at 11.
Back at 11?
Okay.
Okay, thank you. Yeah. You want me to just?
Yeah, start with 1980, then
Okay.
photograph falls.
Okay, we're going to resume with LD 1980. Will?
Grab my own amendment real quick.
Okay.
Okay, so we have LD 1980. This was an act to implement the recommendations of the stakeholder group to examine and improve the recruitment, retention, and wellness of law enforcement officers. So as you recall from our last meeting, there were some issues that we brought up regarding some technical aspects of the bill, as well as kind of the scope of the advisory council. So I'm just going to look back to the original bill as well and kind of discuss what this amendment does, what isn't changed in the original bill and what is changed. So first, I think the easiest change here, section 2, this was regarding the electronic death certificate. So there were some comments about including a public safety dispatcher as a first responder in who would be considered for this electronic death certificate notice. Additionally, I brought up some concerns about the term emergency medical care provider. I did double check that definition, and that's used once in Title 22, and that's really referring to hospital personnel. So the standard language that we use is emergency medical services person. So we're really looking at EMTs here. So the death certificate then under the new amendment, it just includes whether the decedent had previously worked as law enforcement officer, firefighter, public safety dispatcher, or emergency medical services person. I think it's a fairly straightforward change, but any comments on that? Take any questions?
Are there any questions? Any thoughts? Okay.
Moving on to section 3 then. This one is going to need some slightly more fleshing out. Thankfully, Paul forwarded me an email from Director Ryder regarding some changes that I think are going to be helpful for this.
Okay.
But so generally the initial bill was essentially requiring that in the basic law basic law enforcement training program, BLEPI, that there was going to be some instruction designed to prepare officers for physiological, psychological, emotional, and physical stress associated with their work, and that training had to be provided in person. There was some feedback from stakeholders that perhaps that this would be training that'd be more appropriate down the line, as officers might not be in tune with, how do they process this training, or what kind of value do they derive from it if they haven't really experienced those things that would, this training would alleviate or at least help with. So the suggestion was require this once within the first 3 years of an officer graduating. Here we are, Director Ryder. I got a very helpful email this morning too about the way that this is drafted, about who this would apply to. Technically for law enforcement officers, it would apply to everybody that falls under that umbrella. So that could include part-time officers and full-time officers, which I don't think is too problematic, but it could include judicial marshals, harbor masters, shellfish wardens, Capitol police officers, and transport officers. So anybody who falls under that umbrella, because those law enforcement officers are technically subject to in-service training requirements under the statute as well. And I don't know, that's really up to the committee of which roles are we targeting here? Is it strictly for full-time law enforcement officers, part-time enforcement officers, or are there other roles that might benefit from this in-service training? So to that point, one of the recommendations from Director Ryder was you could have this apply to those that have completed BLEPI and those who have received BLEPI waivers. They're coming in from another jurisdiction and they've received substantially similar training, so the basic training gets waived for them. So I think that's a subject of discussion for the committee, is who are we intending this training to apply to?
Okay.
Because the way it is drafted right now in this amendment that I drafted, did not realize that it's a kind of a broader scope of who falls under that. And perhaps the committee does feel that those individuals would benefit from it as well. But like I said, that's up to the committee.
Are there any thoughts on that? Representative Ardell?
Thank you, Madam Chair. Will, could you repeat that list of officers again that would fall into that category?
Yes, judicial marshals, harbor masters, shellfish wardens, capitol police officers, transport officers. I think there's some additional under there. I know there's forest rangers, but there might be a carve out too that they don't have to do in service. I'd have to like look at the full list again because I was not aware of it until yesterday. But yes, there's a lot more than I had anticipated when drafting that amendment. It's a law enforcement officer.
Yeah, thank you. I think the BLEPI, just to the committee, I think the sort of BLEPI or BLEPI waiver folks would probably be a more appropriate application of this, because I don't know how much benefit a shellfish warden, for example, would.
Yeah,
you know,
I don't know what. Yeah,
it just seems to me that would be a bureaucratic application that would be something that people would maybe mock in the future.
Any other thoughts or comments so far?
okay.
Okay, well,
So we can circle back to that too, but so this amendment, it still strikes section 4 of the bill, and I think this is still a topic of discussion. So the original bill required that in the board's courses that they incorporate critical incident debriefing in its training program to promote law enforcement officer wellness. And so I think there's discussion of what does that actually look like? Because technically under their curriculum right now, there is a module on critical incident debriefing. And I don't know exactly how that's applied in their training programs. But if there is currently a module on this, then I don't know what that change in law really does, other than I guess perhaps codify it in a way. But if there's an intention of this, not being fleshed out enough, or if it needs to be expanded, then I think that's a topic of discussion. But as I mentioned in the original bill analysis, and still at this point now, I don't know if it really has any practical effect. It's something that if the advisory council is created, that they could look into more about how that might be incorporated into the academy. But as it stands right now, I just don't see an operative effect from that language doing anything. So something that could be figured out now or just stricken from the bill. Any questions on section 4?
any feedback or thoughts?
Okay. So section 5 of the bill is establishing the Law Enforcement Retention Advisory Council. So this is kind of a broader point of discussion for the committee that, again, was discussed last time. We had testimony from corrections. The name of the organization is blanking on me right now. But a corrections union regarding how could this be expanded to not only include law enforcement, but how does corrections play into this? The scope of the initial resolve, I think, was more specifically looking at law enforcement, but I understand the desire to include corrections in this. So I think there's a couple of ways to go about it. Either one, the advisory council, if it is created, if down the road the legislature wants to add more positions to that, if they feel it's necessary, then that could be further legislation. 2, there's language that I added in this amendment that allows the commissioner to appoint additional members when they consult with the advisory council. I went through a handful of other advisory councils and I did not see mechanisms for adding additional members after it's already been created. I think the reason for that is a lot of the advisory councils, I don't want to say a lot, I don't know the exact number, but there are advisory councils where there's some form of reimbursement for the members. So sometimes it's only for expenses. Sometimes it'll just be a flat number, $50 per day. So I think there's probably concerns about adding members after the fact when these positions, might cost money. But as you can see from section 1 of the original bill, this advisory council is not authorized for any expenses. So I don't know of any mechanic that would prohibit this, of allowing the commissioner to add it after the effect or after the implementation. But something for committee members to think about. And the third, there might be other ways to go around it of other mechanisms. It doesn't necessarily have to be through the commissioner, but it's felt like that this was probably the most straightforward way. And And I did talk with Paul about some of the membership and the language. I think in terms of our drafting practices and how things need to be drafted, I would probably stick with this language, at least how the members are described. I know that was brought up during the initial public hearing, so I didn't make any changes there. And I have discussed that with Paul, but he might have some additional thoughts. That's everything for section 5. Oh, sorry. And I just added some boilerplate language for the terms and vacancies. This is essentially, as I mentioned in the first work session, this is super common language for these boards. What are their terms? So they serve a 3-year term. They can be reappointed after their term is ended by the commissioner. If there's a vacancy, the commissioner shall fill a vacancy by appointing a member from the same category who vacated the advisory council, and that member continues to serve for the remainder of the term. Very straightforward, but if there are any issues with that, if you think it should be dealt with differently, feel free to voice that. Okay, that is the remainder part on section 5 then. Any questions regarding that?
Any feedback, any thoughts? Okay,
Okay, and then
Thanks,
last, section 7 here. This is a new section this isn't in the original bill. But this would require that any reports produced by the Law Enforcement Retention Advisory Council pursuant to its duties under chapter 415, the full language, this is the full language, but I guess you're missing the context of the statute. This is just what's required in the Maine Criminal Justice Academy's report and what's required to be included in this. So technically under the Advisory Council's duties, they're not required to do an annual report. They're free to do so, of course, there's nothing prohibiting them. But it's just broadly put in statute of they're allowed to make recommendations to committees, they're allowed to make recommendations to the commissioner. And if they end up producing reports, this would be a mechanism to have it included in the Maine Criminal Justice Academy report. So it's drafted quite broadly, but I think it's kind of hard to fine tune that since they don't technically have any duties regarding report making.
Okay.
But the report that they do create based on their duties, that would be included in the report, the Criminal Justice Academy report. So all of that is to say, the only part I would change based off of the current amendment is I would need to find a way of restructuring section 3. If committee members would like that to only address those certain law enforcement officers that have completed BLEPI or have received a waiver for BLEPI. And that's more of a technical change. I don't think that's really a substantive matter. If members agree with that, I will find a way to implement that. And then that will be something subject to language review.
is that something that would work for people? Oh, okay.
That is all the information I have on the amendment. If there's any questions about any section, let me know.
Representative Perkins?
Thank you, Madam. So, well, can you just one more time explain for me why we're taking emergency medical care provider off of 1B in your amendment?
Yeah, so emergency medical care provider, that was defined under Title 22 as, I can't remember the exact name of the title, but it was like airborne pathogens or blood pathogens, something similar. And so it was the only time that I found that it was used in statute, and that was specifically referred to hospital personnel that were involved in emergency situations. And I guess based off of our previous discussions, because emergency medical services person wasn't included before. So it's really just exchanging emergency medical care provider for emergency medical services person, which seemed to what the scope was more, I think it's just a misnomer.
Okay, I just want to make sure
Yeah,
was clear
so
on
that's
it.
really for the EMT providers, ambulance and that.
Thank you.
Any other thoughts? Any other feedback for Will? Representative Ardell?
Thank you, Madam Chair. Analyst 2, it seems to me you did an absolutely excellent job on that piece of work, the committee amendment. Thank you.
If there's a bill next session pointing out all the issues, then it was a different analyst drafted it for me. Yeah, I don't remember this.
Any other thoughts on this amendment? Any other feedback? Yes, please.
Good morning, Paul Gaspar with the Maine Association of Police, resident of South Portland. My primary reason to get up was to say, whatever you're paying Will, it's probably not enough. Because we have emails going back and forth at all hours of the day and night. And he's truly been an incredible asset. And I think we support the amendments as written because we heard very strongly from the committee their concerns. And they certainly make sense. And Director Ryder has been incredibly helpful, and we want to make sure that we support his ideas and interests as well, which is how we got to the Blitby. I think a lot of this is, I think when you first write these things, you want it to be perfect out of the gate. But then reality steps in and we learn that there are some tweaks that have to be made. And we really look at that as if we're not looking at all of the concerns of the academy, the committee who may grant this, we're doing ourselves a disservice. And we really want to look towards the future as a success versus just the existence of the bill being a success. So I think our only emphasis is that we want to be able to work collaboratively with the academy and the board of trustees to accomplish some pretty important work that we have yet to even scratch the surface on. And we think that in the minutia of reporting and stuff like that, we also, much like the stakeholder report, feel that the work of the advisory council will also serve to help all first responders. I think one thing we would like to reiterate, and I think this was from Representative Bunker, is the fact that we'd like to see the 3 licensed first responders of the academy be kind of included in the fold, which would be corrections, dispatch, and law enforcement, using the same criteria that, whatever that Blitby is for that particular set. Because our real goal was to not predicate this on dictating to the academy what the basic academy should be.
Right.
And I think the purpose of the 3-year period is to build on what is currently taught in the academy and the Blitby, and then see how much of that has been retained, how much of that has been utilized, and can we then in the future discuss possibilities. So we're very much in tune with having this be collaborative versus at the point of the legislature.
Excellent.
Because
Excellent.
I think we all want the same thing. And I include Director Ryder and Commissioner Sawchuk, who has also been incredibly helpful with us. So yeah, I think we took everything that was recommended to heart, and Will has done an incredible job trying to filter out what falls out of my head and then gets brought back to center by Director Ryder with the reality of things. So
Yep.
We're very proud of having been able to work with the committee and with Will. And,
Excellent.
would support the amendments.
Excellent. Representative Perkins, did you have a thought?
No, I did. I was just gonna say, if I remember from our previous discussion, section 4 was what was getting in Micron, that's gone. And I think our analyst, I'll repeat what both gentlemen said, that I think our analyst did a great job drafting this amendment. And with that, I'd like to make a motion of ought to pass as amended with the committee amendment.
Representative McIntyre, second. Any further? Yes,
May I speak?
please.
Thank you. William Doyle, National Correctional Employees Union Executive Director. Thank you. I am a resident of Saco, by the way. I just wanted to touch base. I want to thank the committee for their work, both the Programming Committee and this committee here. Thank you for the amendment. Thank you for the opportunity to speak. However, I want to be very clear and very forward, and let's not leave corrections behind. Corrections officers are the unsung hero of law enforcement. And more often than not, you see me here in this room and in the labor room arguing to include corrections in laws that have already been on the books that affect law enforcement officers for years prior to corrections officers getting involved, including communications officers. The NCU represents 9 out of the 15 county jails, including that are communications officers who are in the collective bargaining units with the corrections officers. So we represent communications, law enforcement, corrections. So we want to make sure that, again, as Paul said, all the MCJA accredited or certified personnel are included in this, because this is an important topic. Desert Waters did a study in 2014 which I've submitted before this committee before, about PTSD and the situations involving corrections officers that deal with inmate populations for long periods of time. So corrections officers need this psychological, emotional, and physical stress training because they're incarcerated with the very inmates that they oversee day in and day out. And with the staffing shortages that I'm sure you're all well aware of in these jails, it's happening for 8, 12, 16 hours a day. And just to, and this is no disrespect, well, please don't take it as a disrespect, but just here in this committee, the analyst who did a great job couldn't remember the name of the organization that represents the correctional officers that testified before you in the committee before in the public hearing. We are often getting left behind as the correctional officers and representing the correctional officers in the state of Maine. So please don't exclude them. In section 5 of the amendment here, you have a member from the Fraternal Order of Police. You have a member from Maine Association of Police. Why not a member of the NCEU that represents a large number of corrections and communications officers in the state? That's not a hard ask, right? That's not a hard thing. Why wait and let the Commissioner of Public Safety appoint this person in the future? You have the ability to do it now. Don't wait. Because again, it might become one of those situations where down the road, I'm saying, hey, we can't get appointed. Can you appoint us? Can you change the law? So again, I just want to thank you all for your time, but I do want to stress the importance of this stuff. I mean, and you've heard it, so I won't belabor it, but communications officers, they're the first point of contact, right? When somebody's having an emergency, somebody's choking, and a child calls the emergency dispatch. Who's answering that call? The dispatcher. And then that dispatcher has to relive that trauma every time they pick up the phone. They're reliving a trauma because they don't know what it is on the other line. It could be somebody trying to break into a home. It could be a medical emergency. It could be an assault happening, right? It could be a number of things. Same thing in the jail, right? Before the fire department gets to the jail, before the state police, before this, before that, corrections officers deal, they are the first responders in the jail. They're the ones that cut people down that are hanging. They're the ones that sew people up or try to sew people up and stop blood wounds that are happening. Again, we only ask that you include the corrections officers and communications officers in this bill. And with that, I yield and I'll stand for any questions.
Are there any questions? Senator Searway?
Thank you, Madam Chair. I appreciate you bringing this up to us. And I was just going to ask if we could have maybe the director come up and see if that's something could be fit and just added. So if we could do that, would that be all right?
Yes.
Thank you very much.
Thank you.
Morning.
Good morning.
My name is Lincoln Ryder. I'm the director of the Academy. What Mr. Doyle brings up is a good point. I think historically, corrections has kind of been in the shadows of law enforcement, and it is the main criminal justice academy, not the main police training academy.
Right.
And it's intended to capture all those disciplines. And so we don't license dispatchers, but we license, certify police officers, law enforcement officers, corrections officers, and now probation officers. Those are the three main categories, and there are many subcategories of law enforcement officers that you've heard today from Will's explanation. The strength of creating this training that would be post basic training for 3 years is once it is developed, that can be modified to meet the specific needs of corrections, or it could be a class that could serve both disciplines. And I don't want to talk too much about what is appropriate, because really that requires SMEs to be in that conversation. But there are other options. And certainly we want to provide those same resources. And the points that he made about the need for corrections officers is absolutely relevant and real. And they are exposed to other trauma, just like the rest of us. And so the strength of the training is once it's, even if it stayed the way it is in this bill, once we create the training, it can serve all the other disciplines. So, and part of the work is you do have exposure from the job, but everybody comes to the job at some level. And so certificate holders that have, prior childhood trauma could experience something at the very early stages of their career that could trigger that. And so it's not, we can't think of it kind of as a linear travel because you might peer on that line at any given point. And so you could have a shellfish warden, for instance, that has prior military service and has those same exposures. So all that exists for all those disciplines. So I think it's important to provide a resource for corrections as well.
Yep.
And I don't have any issues with their representation within this committee. And I did not speak specifically with the commissioner about that. But I suspect because of the nature of the work we're doing, that is important. One of the considerations, not to get too far into the weeds, is what it's called. And so, and I had it just a second ago. The committee, I think, is called
The advisory council or?
Yeah, so it's targeted towards law enforcement retention. And certainly it should be under the Department of Public Safety because we are a division of the Department of Public Safety.
Okay.
But it may be more appropriate to say Criminal Justice Retention Advisory Council, because if we're going to serve all those disciplines,
Okay.
to name it this one thing, it points in kind of the wrong direction. And again, maybe exacerbates what Mr. Doyle.
Okay, Representative Perkins?
Thank you, Madam Chair. I'd like to modify my motion then, or amend my
Yes.
motion.
Yep.
I'd like to make a motion off to pass with the current amendment with the following changes. In section 1B, put in there safety dispatchers, corrections officers, or emergency medical services persons. Got that, Will?
Yep.
Under section 3, last paragraph, 3 years of a law enforcement officer or corrections officer receiving their certification from the board. And under membership in section 5, add a statewide association representing corrections officers or corrections professionals, however it gets worded. And then also based on what the director just said, if you could come up with an appropriate name change for the advisory council. And that would be the modification to my motion.
Did you get all that, Will?
I did. So if we're adding a member to the advisory council, do we still want to include the language? Because I mean, that language was really added with corrections in mind. The commissioner may appoint additional members in consultation. Do you still want that language to remain, or do you think now that we've added corrections?
I actually don't mind leaving it in there.
Okay.
Just give the commissioner a little bit of leeway and discretion, because there may be things that we're not seeing. that
Sure.
Pop up in the future, and is or her discretion, they may want to add somebody to that.
Okay. And then, so just to be clear, so that would be for section 3 as well. So we would have that for in-service training for law or for corrections officers as well, since we've moved past BLEPI. Plan the corrections, yeah.
Go back to your.
But I think that's the intention, because we were discussing BLEPI at the outset, their core curriculum, and I know it's not BLEPI for corrections officers. But so we're talking about like the core curriculum. I think we've moved past that. So if we're doing for in-service then we're going to do in-service. Okay. So for both of them.
And as it's written, you would want to capture, because the BCTP, so Basic Corrections
Right.
Training Program, also has a waiver process.
Mhm.
So I think what you want to make sure that it captures.
Don't worry, I will be reaching out to you to find the committee's permission to speak with the director for technical changes to the bill for an amendment.
Yes.
Yes, okay. Yes, we will hammer these things out to make sure that it's correct and then come back on language review to make sure we've got that. Because that was a very helpful suggestion.
And if it's framed like that, I think, once the course exists, if you had an agency that had a part-time officer that wanted to avail themselves of that training, once it exists, like, I would not envision us saying, well, no, you're not full-time.
Yeah.
It exists, and if you need it or you want it,
Okay.
you can have it. And we just need to be able to provide the capacity.
Okay, so you've amended your motion. Is the second?
Yes, ma'am, I would like to second the amendment to the amendment.
Okay. Is there any further discussion on this? Are we ready to vote? Thank you very much.
Thanks. Okay, we have LD 1980 with the motion of ought to pass as amended by Representative Perkins and seconded by Representative McIntyre. Representative Hassenfuss,
Yes.
Representative Nutting,
Yes.
Senator Searway,
Yes.
Representative Abdi,
Yes.
Representative Perkins.
Aye.
Oh, I'm not. I'll start repeating them after you. Representative Perkins says aye. Representative McIntyre.
Yes.
Representative McIntyre says yes. Representative Bardell.
Yes.
Representative Bardell says yes. Representative Bunker.
Yes.
Representative Bunker says yes. Representative LaJoy.
Yes.
Representative LaJoy says yes. Senator BB Center.
Yes.
Okay, we have 10 in favor of the motion and 3 absent. And that's where it stands.
Excellent. Thank you. Are we able to move on to LD 1671?
Sounds like Rep. Milliken might have requested somebody specifically on Zoom from Public Defenders
From 16
for
for 1671?
1671.
And she's next door in judiciary, so perhaps you want to do the other one?
Maybe we could do 882? Why don't we do LD
You guys-
882?
Okay. Okay. Get my files. Oh. Okay, we have LD 882. This was an act to protect communication with providers of critical incident stress management peer support. So at the last work session, there was a request for graphics. So I have a document, this is a flow chart of the current law, and attached is our committee amendment that we had voted out in the first regular session. So just to give a brief overview of where we're at with this again. We went to judiciary for a full review because we were creating new public records exceptions. And the judiciary, I provided at the last work session a memo from the Judiciary Committee voicing some concerns about the expansion of confidentiality records and how this might not be as narrowly tailored as it possibly could be. And they had some suggestions for us, which we discussed at our last work session, and I think things got a little confusing. So here we are again, trying to figure out what the correct balance is for LD 882. So starting on the first page here, under current law, I think it's very important that you have a critical incident stress management team. This is where the protections really kick in for somebody. So I think that's your first step of, is this group of people, is it statutorily designated as the critical incident stress management team? We're going to ignore the stop signs for now. We're just going to go through the current law and then we'll circle back to those. So right now, this CISM team, this can be a volunteer team coordinator by a non-entity profit or a team of CISM peer support persons. Under the statute, that definition of a peer support persons is just somebody who provides those peer services to an employee or a member of a public safety agency or a corrections officer or an employee of a county jail or detention facility operated by the Department of Corrections, an employee or member of an organization involved in emergency care response that has been involved in a critical incident that can reasonably have a devastating, long-lasting effect on that person. So team of CISM peer support persons, you see that's kind of fleshed out quite a bit in statute. I'll admit this sibling over here is kind of alone and doesn't have much to it. This volunteer team coordinator by a nonprofit entity, I'm not familiar what that's referring to, and there's no definitions regarding what this entity exactly is. I don't know if it's too important because I think the primary concern of when probably a group is I guess you could say disqualified or doesn't meet the statutory requirement, is that whether it's the team of CISMs, peer support persons, or volunteer team coordinated by a nonprofit entity, there's two requirements. They've got to be trained in accordance with national best practices and standards established by the Commissioner of DPS, and they have to have an established relationship with a licensed mental health clinician. So if they're missing these portions, then it's not statutorily designated as the CISM team. I have an inkling that the final one, the established relationship with a licensed mental health clinician, is probably under current law. The difficulty of actually having the CISM team, I don't know how difficult it is to obtain this person. They are only required to be available to them. They have to be available at one meeting, like physically present for that meeting, maybe not physically, just present for that meeting. And then in general, they're just supposed to be available if the CISM team needs them. But that once per year requirement is perhaps the difficulty in why this is being expanded under the new law. So that's what a CISM team is under current law. Looking at the left side of the document about where LD 882 changes these things, there's an addition that a CISM team includes, or it adds a peer team, which just has to be trained through an organized peer support training program. And that does not require a licensed mental health clinician. The new law maintains still a CISM team. So under current law that we just explained, this can still exist in its own entity, in its own bubble, but that's not the only option to have these confidentiality protections. You can have just this peer team, and the requirement there is just that they're trained through an organized peer support training program. So that lowers the barrier in terms of who is eligible for these confidentiality protections under law. You don't have to have this person. So that's part one of really who are we looking at? When do these protections kick in? And then the part two is, well, what are these protections? So the next page is what information is the CISM team required to disclose or keep confidential? So broadly speaking, all proceedings, communications, and records connected with the work of the CISM team is confidential in civil matters only. So what that means, that information is not subject to compulsory legal processes, it's not admissible in evidence, and it's not discoverable. So that those materials are protected under current law if you have the CISM team. There are the exceptions under that. So one, the confidentiality is waived by the affected person. Two, the information being sought is statistical data for the purpose of a statistical evaluation. And three, a mandatory disclosure of law applies, and that's broken down under statute into three additional sections. So mandatory disclosures, if it applies, one, well, really three under this still, an admission by an affected person that they've committed a crime. 4, a disclosure of info by an affected person that would lead to a reasonable belief that the person is a danger to themselves or another person. And then 5, a disclosure of info by an affected person that must be reported pursuant to any applicable laws. The main two that I could find and that are referred to in statute are for incapacitated or dependent adult abuse, and then child abuse. Those are the two mandatory that I know of. There might be more, but I'm not entirely sure. And then for those three specifically, there are exceptions if it's protected by a privilege of law recognized by the state. For my research, 4 and 5, those statutes are very explicit that they are required. So even if you're a licensed social worker, I don't think that a privilege applies in 4 and 5. I couldn't find anything at least that would protect them on some other statute that protected them from disclosure. Those seem that those are required, and they specifically mentioned disclosure requirements in those statutes. And I detailed those in statute for your reference. The one that I didn't see about any additional protection of a privilege of law would be an admission by an affected person that they have committed a crime, which is relevant because we're going to look at the signs now about what LD 882 changes. This was removed. An admission by an affected person that they have committed a crime would no longer be a mandatory disclosure under the new law. So that was the significant change that judiciary requested that we add back to the bill, as well as number 2. I won't hammer this one too, because I don't think there's any huge disagreement on this about statistical data being available for the purpose of evaluation. And then last 2, as I mentioned at the beginning, all these proceedings communications that are protected, that only applies to civil matters. So this expands it to criminal matters. So what you're doing is the barrier is being lowered on when do these protections apply? And the protections are further being expanded by removing the statistical data portion and admissions of an affected person that they've committed a crime is, allowed further protections now since that would be removed from the statute. So judiciary's point was barriers been lowered, protections have been increased. These kind of confidentiality exceptions is they try to tailor them as narrowly as possible. So what that ends up looking like is up to the committee. But that's all the information I had. And I know that Representative Hassenfuss and I went in circles last time about who this applies to. Hopefully this helps. I feel like I have a slightly better understanding, but I'll admit the statute is a little messy, it seems. So.
Any response, any questions, thoughts? Representative Hassenfuss?
How would the committee feel about amending the bill to ensure that it's not giving any greater confidentiality protections than what is currently in law? So essentially, an admission that the person committed a crime would not be privileged confidential information.
Representative Perkins?
Madam Chair, I think that's kind of the whole point of the bill, though, is to provide additional confidentiality that what is currently provided. So, I mean, if that's the case, if that's the committee's goal is to not provide any more protection than what's currently provided, that would, to me, would be, don't mess with anything, just ought not to pass. But I don't think that we should have to go through some big, long process to create something that doesn't need to be there. But I think the goal of the bill is to provide additional protections and additional confidentiality.
Other thoughts? Welcome back.
Paul Gaspar from Maine Association of Police. I have a very tertiary relationship with this bill, as you met with Sergeant Close, who's also to it. And I think in response to Representative Perkins, I think that the true nexus of this is the issue of confidentiality as it pertains to peer support people who are not considered licensed clinicians, have no confidentiality. Therefore, they would have to let individuals know that, and knowing that whatever is discussed in peer support is not protected is a huge impediment to having first responders come forward, whether it's civil or criminal. And I would agree. I think this is a therapeutic endeavor, and the volunteers, the peer support people who are trained as peer support people, but don't rise to the level of clinicians, although they are supervised by a clinician, that is a huge concern of people not trusting the process and getting in a situation, whether it be civil or anywhere, where peer support people would be forced to testify in a civil case and therefore destroy any credibility or trust in the process. So that was really the nexus of it and why it was important to include from the as well. So,
Other thoughts? Please.
Thank you very much. William Doyle, NCEU. I'm going to follow Paul here a little bit. Again, the importance, representing correctional and communications officers, the importance of protecting the individual in this case is related to collective bargaining and really related to when somebody is disciplined and when you go through the disciplinary process, you're provided with guarantee rights under a 1970 something Supreme Court case law related to not incriminating yourself. And if you don't have those protections of those folks, anything that they say can be used against that individual. What Garrity does is Garrity says, okay, you have to compel, right? We're compelling you to give us all the necessary and truthful information related to this situation. But in doing so, you won't be charged with a crime related to any information that is obtained through this internal investigation of the municipality or a public agency. So in Garrity, if that protection isn't there, again, as Paul kind of indicated, law enforcement officers aren't going to come forward and aren't going to use the program. And then the program, for all the good intents it's supposed to do, is lost, right? And so, again, I just kind of reiterate that with the idea of collective bargaining, the idea of disciplinary measures, and the idea of Garrity in mind. Thank you.
Thank you. Other thoughts, responses, actions? Representative Hassenfuss?
I mean, there is a benefit for, certain crimes being confidential. Like, for instance, if somebody has a drug habit or alcohol problem or things like that, they might disclose certain crimes that they've committed in an attempt to get help and treatment for that. And if they know that they're potentially subject to prosecution for that and putting their fellow officers in an awkward situation where they now know that a crime has been committed and have an obligation to, further investigate that. Is that sort of counterintuitive to what the intent of this is, to offer help for that individual who may be violating the law as a result of a past trauma of service or something like that. But then again, there may be some very egregious crimes, or perhaps crimes that could go towards, the integrity of that officer that may also be kept confidential, that in, the public interest probably should be brought to light. So I think that's kind of that fine balancing act we're trying to figure out here.
Yes, Senator Searway.
I was wondering if we could have the sheriff come up and maybe speak on this, because, this affects their agencies, I'm sure.
I'm Chief Deputy Kurt Andrew from Knox County. Although the Maine Sheriff's Association does support the bill, we didn't provide any written testimony, but one thought that comes to mind is we do have the public safety exception. If someone tells a therapist or someone else, they have an obligation to report that. So where would that fit in with a peer support person? Do they have an obligation to tell if someone it's a public safety risk? And I think that could be a broad term used. What is a public safety risk?
So you're saying that it should be not necessarily linked to their job. So you could be looking at.
Well, I mean, you could make statements that you're going to harm someone or something like that. And I do agree with Representative Hassenfuss' statement about the integrity, or if there's something that could impeach the officer. And I'm not speaking for the MSA on this, but this is just me personally. I think we would want to be concerned if we have someone that is being untruthful, but it's not a black and white answer, because you're seeking peer support. You're not under oath. You're not under an official internal investigation. So I think I would be concerned about someone's dishonesty or integrity. Not to say that we want to involve ourselves with officers' personal lives as far as someone is suffering from substance use or, things like that.
I kind of follow up,
Please.
I kind of hear you because I had to deal with situations like that where somebody had an operation on their jaw and he said kind of not jokingly, but kind of out of the pain that he was experiencing, just saying, I might as well not eat, thinking, and his sister took it as he's gonna kill himself, because stab himself. So it can be interpreted differently.
I mean, do a lot of people rely on erring on the side of caution when it comes to a public safety matter? Yeah,
right.
That's a question that has to be answered.
So I don't know where to go with that. What's your thoughts on that?
So I think in terms of a public safety, it feels like, the current law and in the provided law is that if the person reasonably believes in their judgment that the person's a danger to themselves or others, which I think would be if they're a danger to others, that seems like it could be a danger to public safety in general, then that's already one of the exclusions that can be disclosed right now. So to that extent, because there is some interplay there, right? There's crimes that can't be disclosed, but then you have this public safety, which what if there was a crime that implicated that there might be some sort of danger to themselves or danger to others? So I see where Representative Hasenfuss is going. How you draft that carve out, I'm not sure.
I mean, can I go ahead?
Yeah. Please, no,
I mean,
please.
are we looking at, someone discloses a crime against a person? Maybe in the rare case, someone tells a peer support that they may have had a sex offense type situation. And these are questions that have to be answered. Is it crimes against the person that needs to be reported? But again, I'm getting back to, we don't necessarily want to dive into the lives of officers. We get that everybody has issues in their home life. People suffering from substance use, people having, marital problems and the like. That's not what we want to get involved in. But what is the middle ground?
Representative Perkins?
Thank you, Madam Chair. The part I'm struggling, with is as we're having this whole discussion, we keep talking about all these things that I don't actually see proposed in this bill. We talk about, we almost talk like when these people are going to peer support, one, they're going to confession, which is not what the bill says. The bill, if you look at the wording of the bill, it says that if someone comes to you in peer support, you can't be compelled in a court case. That doesn't mean you can't tell somebody something. It's the way I read it. Correct me if I'm wrong, but it doesn't mean that, hey, you can't talk to the chief on their behalf. That doesn't mean that information can't be disclosed. And then we talk about, we act as if everybody that's going through this peer support process is committed crimes or admitting to crimes during this. And then the last part is we talk about, well, we kind of have these requirements. It's specifically written in the bill that if there is already in law a required to disclose something, none of that, being compelled to go to a court case doesn't even apply. So this is where I'm at. I think that there's very specific in this bill. All this says that is, if, let's say a fellow officer comes to you and says, hey, I'm having problems. I need to talk to you as a peer person, not as a clinician. And you sit and talk with that person. And then as a peer, you say, hey, we're going to get you some help. You can't later you can't be compelled later to go into court on that. And everything I've heard since we've started this bill, we've expanded this into something I think it's
It's not. And we're talking about carve outs that I don't think need to exist. We're talking about examples that are so far beyond the realm of anything that I've seen in my very short career that it's almost ludicrous. And now, years ago, long before we do peer support the way we do now, and I support the way we do peer support now, when we first started doing peer support, and it was not as formalized a program. We're talking 20 years ago, 15 years ago. We just started to recognize that, hey, talking to a peer, a fellow, was a lot more effective than going in and talking to somebody that had no idea what you dealt with on the job. And this is where this all stemmed from. And you tend to go to talk to somebody who's been through the same kind of incident you've been through. So if you've been through a shooting, you went to talk to somebody that had been through a shooting. You know, if you've seen a horrific crash and multiple dead bodies, that's the type of person you went and talked to. Or that's the type of person the chief would say, hey, go talk to this person, because they knew they needed it. So I've had multiple people come and talk to me about shootings or this and that and everything else. And never once in any of this was it, hey, I have to talk to you because I committed a crime and I need some kind of cover. It was always, I can't sleep at night. I'm hurting. I'm angry at my kids. I'm stressed out. And that's what we need to be focusing on. And yet, ever since I've been in here, all I've heard is, hey, you know, all these cops are committing crimes and they're just looking for a way to cover their butt. And we need to make sure that everything's disclosed. And then the bill that's presented to us, if there's a disclosure that has to happen by law, that's already in there. So I strongly support the bill that's written. And I wanted my thoughts out so that the committee understood where I was coming from. But I do support the bill. I think we're making way too much of some of this other stuff that we've been talking about. And I'll be honest, Madam Chair, it's irritating me.
Okay. Representative Hassenfuss?
Thank you. And Will here, please fill me in where my memory doesn't serve me, but I believe that when we passed this bill last year at a committee, we were giving peer support teams the same confidentiality protections that clinical social workers have.
If you are a CISM team, so that you have at least some sort of engagement with a clinician, yes.
Yes, if you are a team in part of not just a random colleague, but you are part of that team.
Yes.
And that this bill would then extend that and say any member of this team, if it's part of that process, that everybody on that team would get the same confidentiality and disclosure protections that an LCSW would have. By virtue of that, we get 4 and 5 as the 2 mandatory disclosures that are required from an LCSW by law. And so that was my understanding of the bill as it passed. And I said, I think that makes sense. When it went into judiciary for the FOA review, that committee kind of questioned the sensibility of that, which is why I came back to this committee to say, you know, did we all understand and mean to and want to apply those same constitutionality protections that an LCSW has to everybody in this peer support team? Because that's what I think the bill as written does. Will, is that your understanding as well?
Yes, with the addition of now it applies to criminal as well, but you're right that in like the social worker and the professional counselors that it applies to civil and criminal for them as well.
Yeah.
So,
And there are exceptions to that where like a counselor can be compelled to testify in a criminal case after certain judicial review, which I think also would apply to the peer support team. So that the question, like the real question that I held this bill and wanted to ask the committee, and I think Representative Perkins sort of hit that, is do we feel comfortable that the state should extend the same confidentiality protections given to licensed clinicians to every member of this peer support team?
Please.
Thank you. Paul Gaspar from Maine Association of Police. I want to tie into what Representative Perkins discussed because and I'm paraphrasing because I don't remember verbatim Sergeant Close's testimony from the initial work session, but we very rarely have issues of criminal behavior coming up in peer support, but it wasn't until Representative Perkins brought up the issue of peer-to-peer where it's important to note that a police officer who has been involved in a shooting ultimately is investigated for a crime, homicide, by the Attorney General's office. Therefore, to me, that's the penultimate example of why we would want to have that, because it's investigated as a crime. The officer could be charged with a crime if the AG's found that the shooting is not justified. However, you're not admitting to a felony murder. So, and if the peer support folks do not have that confidentiality in talking about the officer's experience in that shooting, officers will not come forward. That's kind of this niche thing where I believe that we would see more of that than actual serious felonious conduct. And I know that Sergeant Close did reiterate that this is not meant in any way to circumvent the mandated reporting of law enforcement or clinicians. So I just wanted to give that example because it's that very gray area of a criminal issue that is technically is at the behest of the state in their duties. So thank you.
Thank you. Any other thoughts? Yes, Representative.
Thank you, Madam Chair. It's just a question for Will. I'm unfamiliar with this process of sort of getting the bill back from judiciary.
Yeah.
What are our options?
So I mean, technically, I think this would fall as a reconsideration of the bill. So those are their suggestions. I mean, if you want to it would go back out as ought to pass as amended with the same language, then it would go back out to the floor and then you guys would vote on it from there. Or if you wanted to do additional amendments, then it would go through its regular process. If I would implement those amendments, send it to the revisor's office, we do language review, then it gets reported out back to the floor.
Okay, thank you.
What would you like to do?
Well, Madam Chair, thank you for asking. I think Representative Perkins made a lot of good points. I think there's a lot of, the Judiciary Committee may have sort of burrowed into some minutia that really is not really in the spirit of the original bill. I think having looked at the vote list, I think that our committee was uncommonly unified on the original bill, and I think had a very good sense of it upon our initial hearing. And as a result of that and of some of the testimony today, I'd like to offer an ought to pass motion on the original vehicle that we had voted on first, if that makes sense.
Yeah. And that did include a language review. We included the provision about the statistical data for purpose of evaluation.
Yes.
So include that.
And it just in closing, I think that the last paragraph of the original bill, and I'm quoting, "This section does not prohibit disclosure by a provider of critical incident stress management peer support of information concerning a person served when that disclosure is required by law. And this section does not modify or affect the provisions of Title 22, Section 4011-A to 40-15. So I think that protection remains in effect with our original vote, with the original bill.
So what are our next steps? How do we,
Well, motion was made, so yeah.
and now a second, okay. Any further discussion? Representative Hassenfuss?
That motion includes the piece about reporting data.
Yes.
The other recommendation from the judiciary that
Yeah.
there's really kind of no issue with.
Yeah.
Any other thoughts or discussion? Probably. Representative Hassan Are we ready to resume?
We're gonna vote on this. But they can.
We have a motion on the table and a second.
The motion on the table for LD 882 is ought to pass as amended by Representative Ardell and seconded by Representative McIntyre. Representative Hassenfuss.
No, on not to pass.
Senator Searway. I'm sorry. So sorry. And Representative Hassenfuss says no. Representative Nutting.
Yes.
Representative Nutting says yes. Senator Searway.
Yes.
Senator Searway says yes. Representative Abdi.
No.
Representative Abdi says no. Representative McIntyre.
Yes.
Representative McIntyre says yes. Representative Ardell.
Yes.
Representative Ardell says yes. Representative Bunker.
Yes.
Representative Bunker says yes. Representative LaJoy.
Yes.
Representative LaJoy says yes. And Senator Beebe Center.
Yes.
Senator Beebe Center says yes. So we have 7 in favor of the motion, 2 opposed, and 4 are absent. And those of you opposed to the motion?
For ease of operation, just a straight on to pass.
And do you agree with that, Representative Abdi? Okay. Just missed it.
Would you like to call absentees, Bernice? Would you like to call
Okay.
absentees?
Absentees, Representative Perkins. I'm sorry, the motion is ought to pass as amended for LD 882 by Representative Wardell and seconded by Representative McIntyre.
Yay.
Representative Perkins says yay.
So the total for the total
So
vote?
now the total is 8 in favor of the motion ought to pass as amended and 2 ought not to pass and 3 absent.
Thank you.
Yep.
Thank you. So I believe is she gonna come back? Yeah. Can we check and see if she's gonna get back? Sure. Okay.
Sure, yeah, and
Transitions?
just to be clear, we're now opening the work session on LD 1671, an act to establish disclosure requirements regarding law enforcement officer creditability information. It's my understanding that Chief Moen and Attorney Burns discussed this. I think everybody agrees that this needs more work, more discussion, more process here. My recommendation for the committee is that we vote on not to pass with a letter to those interested parties that says, we appreciate your work. Please continue to, find a way to address this and come back to the legislature next year if needed. Representative Perkins?
I believe when we took the tabling motion, there was already a motion on the floor of ought not to pass. So I believe that motion is still valid and current.
Okay, yeah, so if there was already the motion of on not to pass, that's still valid. And I would just like to suggest we add a letter to it to say, please keep working. Representative Perkins?
If that's the case, I'd like to amend my motion to add a letter directing the relevant parties to continue their work and or the letter as you described it, Mr. Chair.
Representative Milliken, whoever seconded Representative Perkins' motion, do they concur? Senator Seaver, do you concur with that?
Yeah, I second that.
Okay, Representative Milliken.
Thank you, Mr. Chair. Would it be okay to add to the letter that we include the voices of the criminal defense attorneys in that conversation?
I think that's appropriate, and the courts, because the courts
as
may
well.
also play a role in this.
Thank you.
So I think just including all of the interested parties, attorneys, courts. Not. Is that amenable to the letter, Representative Perkins and COI? And I mentioned court because if there is some sort of in-camera review process, they're going to have to be part of that. A defense attorney will be part of that. So I think it's just, having them understand, knowing that the real.
Yeah, I'll agree to those.
Is there any further discussion? Are we ready to take a vote?
Does anybody want to ask?
We have a motion on the table and a second.
The motion, the LD 1671 has a motion not to pass by Representative Hassan and seconded by Senator Searway.
No.
I'm sorry. Pardon me?
Yeah, he was the first.
Okay, Representative Perkins made the motion, seconded by Senator Searway.
Yes.
Correct.
Yes.
Okay, sorry about that. And Representative Hassenfuss.
Yes, on not to pass.
Representative Hassenfuss says yes for the motion. Representative Nutting.
Yes.
Representative Nutting says yes. Senator Searway.
Yes.
Senator Searway says yes. Representative Abdi.
Yes.
Representative Abdi says yes. Representative Perkins.
Aye.
Representative Perkins says aye. Representative McIntyre.
Yes.
Representative McIntyre says yes. Representative Vardell.
Yes.
Representative Vardell says yes. Representative Bunker.
Yes.
Representative Bunker says yes. Representative LaJoy.
Yes.
Representative LaJoy says yes. Representative Milliken.
Yes.
Representative Milliken says yes. And Senator Beebe Center.
Yes.
Senator Beebe Center says yes. So we have 11 in favor of the ought not to pass motion and 2 absent. Thank you. Not official.
Do you want to discuss anything about how we're not quite meeting the deadline and what we need to do?
No, I think So I'll submit a memo, that'll be reviewed by the chairs, so it's technically submitted by the chairs, requesting 5 carryovers, not carryovers, an extension of our carryovers. So that's the judiciary bills that were supposed to be worked this Monday.
Yeah.
LD 16 through 19, and then it's LD 102, escape juveniles is the other one we'll request an extension on. Those will come up. We're gonna meet right after this to do scheduling, so hopefully we'll have some notice to you about when we're meeting next week. And hopefully we can reschedule everything. We also had the county jail funding report that was on the schedule.
Right.
So we're gonna try to do all of that ideally next Monday, but you will know very soon what the plan is.
Okay, yes.
Madam Chair,
Representative.
thank you for recognizing me. I had spoken with analyst 2 about the possibility of a letter to the Secretary of State, who as a constitutional officer is sort of responsive and responsible to the legislature regarding her policy to refuse to provide civilian license plates for federal agencies who are conducting and there was a lot of the use of the word undercover, but it's really what it is plainclothes law enforcement operation. That would, I mean, I understand her political motivations for doing so. But the policy that she appears to have put into effect encompasses a lot of other operations as well. You know, creates an inability for plainclothes federal law enforcement to conduct surveillance. Because without state provided license plates, you know, for plainclothes vehicles, the only other option is to provide license plates that are GSA plates, which you would typically see on a recruiter's van, for example. That's not, those aren't appropriate tools for plainclothes federal law enforcement. And this could include the U.S. Marshal Service serving warrants, the FBI conducting terrorism investigations, Homeland Security investigations, conducting investigations into fraud. For example, alien trafficking or child exploitation investigations. The list goes on. And I think the Secretary of State has taken a very unique and extreme position in refusing to do this, particularly with the situation of the rollout between the loss of the chickadee plates and the issuance of the sort of new kind of cartoon pine tree plates. I did the math, and somewhere short of 30% of, if federal vehicles, plainclothes vehicles are issued registrations at the same rate throughout the year, somewhere between the middle of January and the end of April, that 30% of those vehicles would be refused civilian plainclothes license plates as a result of the Secretary of State's decision to not provide these. What I would like to propose to the committee is a letter to the Secretary of State, because it seems like it's an issue that would fall under the Criminal Justice and Public Safety's committee's purview. You know, this is that we represent, this is something that sort of falls into our sphere. And what I would like to do is ask Will to work with Will on a letter to the Secretary of State, and I would invite the members of the committee to sign on with me and my colleagues.
I thought it was specifically for ICE.
No, it was for all federal. As a matter of fact,
Much broader.
CBP plainclothes vehicle had been refused, and the U.S. Marshal Service to date has been refused. There may have been more since then, but this would include investigators of SNAP fraud from the U.S. Department of Agriculture. The breadth of this is quite wide and broad.
I
What
mean,
are people's thoughts?
Well, thank you for, bringing that forward. I'll certainly consider it, but I don't have any, I don't have any expression today of what letter might look like or what to do there. But you certainly can write something up and forward it for advisement. I'm not sure. Yeah,
Essentially, what the content would be to consider to continue the standard practice that has been going on for decades.
I mean, I think that the appropriate, the easiest, most appropriate would for you to draft that letter, circulate it with your colleagues, and then we could go from there.
Well, I mean, as a committee, I think we have a responsibility, we have a specialty. That's the reason we have committees, I think. And so I think if there was a group within the Maine legislature that would understand the nature and the gravity of this situation, it would be the people around this horseshoe.
No, and I don't disagree with that. I'm saying circulate your letter and then we can move forward from there.
Representative Milligan?
Thank you, Madam Chair. I think this committee has a responsibility and the legislature frankly has a responsibility to uphold our oaths to uphold the Constitution of the United States, and considering the failure of federal law enforcement at this point to have any respect for the Fourth Amendment of the United States Constitution, I would encourage Representative Ardell to draft his letter. I likely won't sign on. And I would offer that we all might reread the amendments to the Constitution.
I think that's the most
Representative
appropriate.
Hassenfuss?
Yeah, I think that's the most appropriate path. If somebody has a letter that, or a request that they'd like to make, I think draft that letter, we can review it and then decide if we take action as a committee or if it's better served through individual letters from representatives. But I think once we see the text of the letter, then we can have more discussion. But for now, I think let's put our thoughts on writing and then we can review back later.
Senator
Yeah.
Searway?
Thank you, Madam Chair. I listened to this and I think of the officers and I think of the public and how things are expanding and getting worse. I mean, this is started with that one bill that caused a lot of friction and a lot of problems, and then now it's continually manifesting. It's kind of like a great big rock thrown in the pond and big ripple effect. It's like taking the computer system out of your car and trying to operate it. And now anything we do trying to fix it, it's not going to run. And that's what's happening. And so I think our committee really should be responsible in saving people's lives. And that's where I'm at. And I think that's where, Representative Ardell's trying to express is that we should, as a group, look at how we can save lives. And we could even, have, where these individuals are affected and maybe have them come to come here and express how it does affect them. But for us just to write, a letter and then say, well, I'm not doing it. I'm not doing it. Well, there's a lot to this because when I see an officer or individual harmed, that's even a public person, I'm thinking every time that we could have prevented this and we didn't. We didn't prevent it. And I'm saying we because we as a legislative group are failing our people and the public and law enforcement and the federal groups. It's that computer we're not putting back in. And so I'm telling you that we really should think about this and maybe do something with it. So that's where I'm at. So
Any other, yes. Representative.
I think
Lovejoy.
Representative Ardell has a viable request that encompasses more than one entity. And it could be detrimental in some way, but we won't know that until Representative Ardell working with what's your name? That we won't know, what we have to look at. So I think it's a viable request and I think we should act. Thank you.
Any other thoughts? It sounds like Will and
Motion.
Representative will put a
Yep.
letter together.
Motion to adjourn. Right, all in favor?